Welcome, everybody. Chuck Cook, Aaron Hall, Jesse Bless, and we're going to excuse our dear friend Greg Siskin, who has a death in his family. Our thoughts and prayers are with him, and a woman who lived a great life, a long, great life, and mom of one of our other very good friends. So it's great to be with you. There's a little bit going on, not a lot going on, but really the first thing that pops to my mind, Aaron especially, is the 601A filing late Friday evening from the government, a reply to our response to their motion to dismiss. Now, I was perusing it yesterday when I finally got a chance to read it, and they're a little defensive. They're a little defensive.
What were your thoughts?
Yeah, I think my favorite part was where they said, defend the plaintiffs, us, misinterpret the Patel case from the Supreme Court, that it doesn't say what we say it says. And it's because you have to read into the case. I don't think was there ever a rule that said you have to read into and make up facts about a case to have it apply to your case? Is that a rule I missed in law school? I may have missed that rule in law school. How you should interpret. One thing I did notice in my overall read of the complaint is they must have used a thesaurus checker this time, because they threw out a lot of big words to make their argument sound more important. I should go through it and quote some of them, but it's like, I haven't seen that word in a brief in at least 25 years. So they must have used a thesaurus checker, if there is such a thing, to make their argument seem stronger. What did you think, Aaron?
Yeah, it's kind of what we expect at this point, and I don't think there's any surprises. I think I'm happy that it's fully briefed, and we are able to get a decision at any time or a hearing set. We'll see. Well,
the court now has several things pending. It's got a class certification request that's fully briefed. It's got this motion to dismiss fully briefed. It does have upcoming a filing, is it tomorrow, right? On the joint status report / disclosures, in which we say we want to depose Urchadu and some of her minions. I would suspect the court would set a date. Now, is there a date already set? I'm going to go back and look.
No.
The court has not set a date for a hearing that I'm aware of. I'm going to go into Pacer and look at her order again, because there was something in there that I had a question about. So I'm just going to quickly do that while we're talking about it. But Jesse, did you have any take on the government's reply brief that you want to share with? We have a lot of people that in the case that listen to our live here.
Yeah, I don't like. Again, it's not surprising. They've taken a position that what they're doing is fine, and in fact, even if it wasn't fine, no one can do anything about it. And I think that's the most important aspect. Is USCIS is really trying to take away the ability for anyone to challenge their wrongdoing, even if it's wrong. You cannot correct it. So they could say, we're going to stop doing all the 601As and keep your money. And there's really nothing that anyone could do about it if they are right. And I hope that the judge understands that they're not right and we're right. Because we can fight over whether 36 months or 33 months or what's reasonable to complete an application. But when you tell a court that you judge, have nothing you can do about it, that's a pretty incredible position. And again, they're also telling the judge that she needs to read somewhere between the lines on a case that had nothing to do with the waiver and nothing to do with the non-removal case, and actually take it and expand through it. Again, it's pretty incredible. So I think objectively as possible, I think we're pretty in a good position to survive. And that's the name of the game. You want to survive. We're not going to win anything on this. We're going to survive.
But surviving in itself is a huge victory, because then gets us to the next stage of litigation, which is discovery, which they really freaked out about. in their response. I mean, they
Yeah.
really freaked out about it.
I think the case ends if we get discovery, because of course, if you actually find out that they're doing things wrong, it makes it very hard for them to defend. They're never going to be in a better position than they are right now.
No, I agree. I agree.
The other thing too is I think if you prevail in a motion to dismiss, it's really difficult to not have a class that's certified, which is another huge aspect. I mean, getting a class certified is monumental, and it's huge.
So a couple things. In one of the footnotes, they said plaintiffs, us, raised the specter. I love that. The specter, the ghost, the hidden cause, the movement without being seen, the specter of USCIS ceasing to adjudicate cases entirely. That is not the facts of this case. Actually, they appear to be the facts of this case.
Well, the thing about it is okay, prove me wrong.
Yeah. So there's that footnote. Then they have another great footnote. Plaintiffs raised several puzzling assertions regarding agency discretion, which they impute to defendants. But none of those points is responsive to the motion to dismiss. They're referring to the fact that we said, look, the agency is taking the position that they could stop adjudicating cases, and you have nothing to do with it. And they just don't address. They just say, "Oh, that's just fake news. It's fake news."
Yeah.
It's fake news.
I mean, again, it's
oral argument's going to be so much fun if she has an oral argument on this, which she doesn't have to have, right? She doesn't have to.
No, but I mean, it's so comical because it's so in line with what we hear out of Washington so many times.
Well, now the other footnote, Jess and Aaron, I thought was hilarious was footnote number 4. Plaintiffs further assert that, quote, defendants acknowledge no harm to plaintiffs from the USCIS's increase of processing times. That is unfair. On the contrary, we defendants have repeatedly recognized the impact delays have on applicants and continue to seek to reduce processing times. In fact, we just created the HART Service Center. Well, we all know they didn't create HART to deal with the 601As. That's why it's named HART, Asylum, Humanitarian Asylum Refugee, and doesn't include waivers. It isn't HART. It's HART because it clearly wasn't intended to be part of it. But you jammed it in so you could go to the court and say that. I mean, that's another piece of discovery we're going to get. Tell us all about the formation of HART and how 601 was in it from the beginning. Not the case. We all know it's not the case. Liar, liar, pants on fire. So anyway, it was amusing response. We'll see what the judge does. Maybe she buys it. I don't think so. And we'll see. We'll see what's happening. So that's it. Well, I'm sure we'll get questions about it. We'll talk more about it. The 601 litigation we were just talking about. This is 601 on consular delays of waivers. Aaron, I got a call today from a lawyer. There's an immigration lawyer. And he's been waiting for 3 years for his 601 for his wife, who's been out of the country 13 years because she had a permanent bar. So she had to survive the permanent bar and then file the 601 3 years ago. I said, we need you in this case. So what are we doing with the case? What's going on?
So we're still within the 60 days that they have to respond. We don't have an attorney that's entered an appearance from the government yet.
Which is normal in the DC circuit.
So, and this one's Nebraska.
Nebraska.
But we have a few people who have signed up after, and so we'll get them in with an amended complaint. And then we'll see whether they're going to actually adjudicate some or all of our plaintiffs, or if they're going to fight this and file a motion to dismiss, or what they want to do. But the clock's ticking, so we're waiting to hear from them.
So join, if you're looking for the 601 waiver, just go in now, sign up. It's way cheaper than using your private lawyer. And basically, every private lawyer is doing this because it's a mass action, not a class action. The other thing that I wanted to make sure I mentioned today was the EB5 case. Where are we? And I need to change this to be higher. Nothing. Judge, we got expedited briefing on this. Oral argument and nothing. You guys have any extrapolation from nothing?
None.
I don't either.
I thought we might get a quick decision, but
I don't know. This is a good question.
Gonna take their time.
I think the longer the time goes, the better it is for you or
I think
us.
so too.
But I mean, I think that the government, it's so similar in all of these cases. The longer the judges actually wait, if the judges are patient, and I understand the clients don't like that, but listen, if the court is patient and allows evidence to come to light, you're going to find a lot of what the plaintiffs say, not just our cases, but other cases, are incredibly true. Meaning there's been intentional delay. There's been going out of order. There is no rule of reason. And if if the rules of civil procedure still mean something, which I think they still do, then the government should have to, be discovered.
Yeah, that's why discovery exists, to establish.
It's so crazy. I mean, I'm so on the warpath against treating immigration litigation different from regular litigation. I mean, that's going to be my next 20 years of my life. I'm going to absolutely undo that, because the way that we've have this bias or predisposition that it's because it's all civil, and it was civil by Congress to keep it civil, and the rules of civil procedure need to apply. And it's just, I think your case is a great example of that.
I think it's a great case. Now, Jess, you have oral argument coming up this next week.
Yeah. So May 11th, there's a consolidated appeal so it's a little bit different from the Jane case. So we're before the DC Circuit. We were dismissed by the district court. Now, in the case that I'm arguing, my plaintiffs were found to be harmed from the delay, that they're in South Africa and they're in a difficult spot economically, politically, civil strife, what have you. And the judge said, well, track factors 3 and 5, go to your client. But the government has this great rule that they follow all the time. And, you're just not in the line yet. And, and so we're going to argue. Number one, that's wrong, even if it's true. It's wrong, because you shouldn't dismiss these cases, just what I just said. But the other thing is, we have an amicus brief that was very well done.
Great amicus brief.
Well, it just tells the truth. I mean, which is apparently, in short supply this time, and it just shows 539 cases where they didn't follow what they're saying. I mean, I've argued for the government. I can tell you right now, and I actually told my wife this, because she's like, "Oh, you going to DC?" And I said, "Listen, this would be the one case that if I was still with DOJ, I would not want to argue, because I can only lose it one way. Because with delay cases, if it goes, you're usually going to lose. But this is, are you being honest with the court? Are you being honest? And the reality is, no, you're not.
No,
you're not.
Really not. You're being honest.
You're not being honest, because you told our clients, and you told the district court judge that my clients were, that you following a first in, first out rule of processing. And that's just not true.
And we're not talking about, okay, some guy filed a week after you got approved before you because got to do it different. That's not what we're talking about.
No,
we're talking about years ahead of you. Years.
And the thing about it is, I actually, let's just assume, for the sake of argument, that we don't care how the government does its job. At least tell us
the truth.
Just say it. Like, what do you do? Do you make it up? Do you is it by region? Is it by regional projects?
Clearly it's not by region, because then no South African would be in line, because there's no backlog for EB-5 for South Africa.
Exactly. So what exactly is the visa availability approach? Like, I just need to know.
Well, it's the rule of reason. Don't you know?
Yeah, exactly. Now we're talking in circles.
Yeah, exactly. Well, that's it. This is a circular government argument.
All right, so let's connect the dots. What is your rule of reason for 601As if you haven't stopped? What are you doing?
Literally, if one of our plaintiffs has been approved, 3 more recently got notice that their case was being worked on.
And I feel like I'm being like over simplistic, but I mean, I should probably not argue any of these cases, because I just want to be like, hey, listen, we're just asking for like the truth. Like, hold on, stop all of like the shenanigans. Like, why can't we just have the details so you court can actually understand what you're doing? Because they're fudging the numbers. And if I did that, if you and I did that, you know what I'm saying? Hey,
well, that's how you get disbarred, by the way.
No, exactly. That's what I'm talking about.
Like, you get disbarred. That's how that happens.
Here's something I know is not true. and I want to make a case. Here's something I know is not true. Decide for me and give me $1 million. Let's see how long that works for you.
Yeah, it's not a good look. All right, a couple other things that are out there. We've got the prevailing. We still doing. If anybody's interested in fighting on the prevailing wage, we're willing to do that case. But you know what? Nobody signed up, so everybody's just fine waiting a year for an advance for prevailing wage on the Department of Labor. Okay, it's really funny. You had all this whining online about and then nobody wants to sue them.
Yeah, I will say, I think they're also DOL kind of got on top of this game.
Well, they are getting, they must be watching our cast here, our webcast. Oh my goodness. Jesse Bless is going to sue us. Let's get this work done now, huh?
No, I think there's some lobbying dollars that probably, knocked on some doors and said, hey, you're killing our business, because it's the employers. There's large employers that have deep pockets who probably want something done. But I don't know. I don't know why. Maybe they figured out that their machine stopped pressing the button to do it. I have no idea.
Now, Aaron Hall, I have to ask about Nikola Jokic. Who is Nikola Jokic?
Chuck, this is why I have to put these things in my name, because some people aren't witnessing what's going on in the NBA right now, and Jokic put the Nuggets up 2-0 in their series last night. So
do the Nuggets still play basketball?
They're probably the.
Yeah, I'm a Hawks guy. Like, that's gonna be anything that I could complain about, right? Hey, so I have to do this. The truth numbers came out. The truth shall set you free, baby. And what ended up? What did we say? 700,000 at least applications. They made at least $7 million. Massive duplicate fraud for people who don't really have real jobs. It's all true. It's like Harrison Ford in the Return of the Jedi, one of those Jedi movies. It's all true, kid. Every last bit of it.
Yeah.
It's true. Immigration made money by deceiving people and allowing them to file lottery applications that had no basis in reality. And
Chuck, didn't I see you say something? I don't know if it was on Twitter or email or something, but hadn't you heard some information from some companies who were pretty upset about this?
Oh yeah, at least one employer is contacting everybody this is actually a Big Four accounting firm. Every one of the folks they filed H's for and said, did anybody else file for you? Because why? Because immigration can come after both companies. And we know that they might. Well, at least they've threatened they might, but there's no indication they're going to do that. They may recall that in the summertime last year, they went out and announced the arrest of a company in the Bay Area. A couple guys who did this, they were acquitted and they were let go free, and the company's still operating.
I'll tell you,
you have to change the rule to make this illegal.
But what they're doing though, they are not enforcing not just these registrations, but also bad H-1B petitions that get filed, and then the people are going abroad, and they're getting beneficiaries are getting 6C findings, and they're permanently barred. Yep. So these people who actually win, it's like,
don't count on
NFL, baby. Yeah, not for long, because you're going to go over to Mumbai or New Delhi or
and they're going to say, sorry, Charlie.
Can't tell you how many times it's happening. And you know what they should do? They should take the $7 million and actually use it to do their job on the other things that they're not doing. Because it's mind-boggling.
They just spent a lot of time redoing their mission statement. So that's not free, It's not free.
Read me the future. What are they going to do? I mean, they're embarrassed about this. What are they going to do?
They're not embarrassed about this. I don't think they're embarrassed about this at all. They should be. I mean, David said avergonzado for sure, but they're not embarrassed by this. They got their hands caught in the cookie jar a little bit, but next year they need this to happen next year. They're charging $215 next year. That's $200 million free dollars.
I can tell you what their solution will be to restrict the H-1B employer-employee consultancy and make it like wage based. I mean, that they're gonna
Make
blame.
rate based, they need a regulation, and we fought that regulation because it was stupid.
I know.
But what they can do, as Greg has repeatedly suggested, is make it about the foreign national. Do it by passport number. You get one. You can put in 80 employers, but your passport number only gets picked once, and that's it. Because you're portable. You can go to other employers if they're all legitimate jobs, and you have 20 job offers, fine, but you only get picked once. Because we got people that are on Reddit, they can pick 5, 6, 8, 10, 12 times. And that's the FOIA litigation I still have pending. How many get people, now they disclose how many people file duplicate applications. What didn't they disclose? How many people got picked twice? The other crazy thing here is they notified fewer winners this year than last year. They never released how many H's they approved for last year, or new H's. They released how many H's we've approved, but they don't separate out new H's. So we don't even know if they hit 85,000. And why do they think if they got more fraudulent applications this year that they should notify fewer winners? I mean, this is begging for discovery. This is begging for discovery.
It's just we're making it too hard. We really are. I mean, they should make it uncapped and make
that's Congress. Well, I will just tell you the Grassley Durbin bill is back again, like a ghost from the forest. Basically making H's almost impossible to get, eliminating L's basically. So Congress is not responding in a coherent way to the problem. And why the House has not had a hearing on this stuns me. You think they'd be very interested in massive fraud.
Well, you know why? Because they have a little thing called the debt ceiling that they can't get their mind around. They're going to have to deal with that.
Biden can fix that problem in a second by minting $1 trillion platinum coin.
Yeah. Yeah. Well, he needs it. Yeah. Okay.
The debt ceiling is there is no debt ceiling.
I hear you. I just think that it's the clown show that is Washington now is focused on the debt ceiling circus. Like that is,
and that's why they're not going to do anything else.
Yeah.
All right, Rachel. If the government agrees to work with travel planes in the plane, will we accept the offer? Well, Rachel has a great question. First of all, we would consult with you. You're our plaintiffs. We don't just make unilateral decisions on behalf of our people. But is that a rational answer? Well, sure it is, because if you get a travel document, you wouldn't need a 601A waiver. You could consular process. You could adjust your status after you get back. It solves the problem completely. Again, I don't think they're going to settle. We're going to see. I think that they got their hand caught here, really screwing people's lives over, and they're going to try to keep covering it up. Another 601A Facebook group, we have seen 2 approved receipt data, meaning if you saw that in a Facebook group, which I don't have access to, you need to print that out and email it to us. You need to screenshot it, because that is clearly against their rule of reason, and I would love to see it now so we could notify the court now that they're not taking cases in case order. So if you've got that, you need to get that to us ASAP. Guys?
Right? Well, I do know that there were a couple cases, because I was the attorney on 2 of them, where we sued and they did before our case that they did adjudicate, but they weren't 2022 filings. They were 20.
This suggests that this is new information.
Yeah. Yeah, that would be helpful.
What do you think of the recent approvals of the 601A from July 2029? Again, Kiara, I don't know about that.
Yeah.
So if you've got evidence of that, you need to get it to us.
Yeah, I need the receipt number.
Yeah, we don't monitor every listserv and every Facebook group on the internet.
Greg does, though.
Greg might be doing that. It's a disaster moving to Canada. Apply for well, you can't you can change to B2, you can change your status, but you can't get a visa inside the United States. All first-time visas are done at consulates, but you can change your status in the United States.
Look at hey, just really quick before we move on, look at the first line there. I'm moving to Canada.
Yeah.
This is what we're doing to ourselves.
No. And Canada's saying welcome.
Yep.
They're going to take 1 million immigrants in this year. It's a country that has 33 million people in it.
Yeah.
It'd be like we took 15 million people. It's insane.
We're just hamstringing ourselves.
Wait time for an appointment is 624 days. Hopefully, is Canada employing former USCIS employees? Is that what's going on there? Maybe former Montreal consulate employees. Moving this July when EAD ends, I get it. Elizabeth, is there a way for people to join the 601A lawsuit? No, because we're not adding people to 601A lawsuit, but if we're class action, then you're part of it. Henderson question, GI hearing was good advice. Just reapply again, ZV, instead of waiting outcome appeal. Oh, yeah.
You can keep applying. You can keep
applying, absolutely.
Doesn't do any harm.
Hopefully, yeah. Funny question. How many messages you receive every day asking about it? I get like a dozen a day. So you get a snarky response from me. And Guadalupe, my signal was transferred out of Potomac for last week. All right, that's great news. Now, if I recall, Guadalupe, they didn't tell you where it went, which suggests it went to Hart, which is not listed on the drop-down menu of processing times. So there is that. What happens to the judge that dismissed 601 case? Okay, well, no, we appeal. We appeal. How long more should we wait for the final outcome? We've already answered this question 100 times. We don't know. We hope to get everything done by the end of the year, but it just depends. Just FYI, a 601 case similar to mandamus filed in Nebraska and Judge Zauert, government filed for extension and the motion to dismiss. Yeah, of course they're going to file a motion to dismiss. Of course they will. So we're prepared for that. We're ready to go. We're ready to go. We've got some good arguments.
Yeah, I mean, I think, and I think too, like I say this again, and the anxiety over what's coming next. I mean, sure, the government's could the government win? Absolutely 100%. Could they win in every case we've talked about today? Yes. Did they win in the H-1B registration? If their intent was to allow for massive fraud, they won. So I don't think we can we can't result. They call it resulting, right? You can't just say, look at a result and say, and work back from there. We're trying to put forward and follow the process so that we can put ourselves in the best position possible. But can we lose? Absolutely. Litigation is like a boxing match. Someone's losing, and if it goes to a vote, guess what? Someone's walking out of there with the belt. We hope it's us, but I mean, it's the same type of questions. We're better than that. Like, let's ask important questions, not about like, what are the chances we're going to win? I don't know. Let me hit the guy in the face and see if he drops. Yeah, like, you know what I'm saying? I can't predict.
We wouldn't have brought this case if we didn't have full confidence in our ability to win this case.
It's a case that needs to be done. It's a fight that is worth fighting. I mean, they're literally freezing out.
You can't let the government get away with this bullshit all the time. Pardon my freaking French, but you cannot allow them to keep doing this because it starts here, and where does it end up? You know what bullies do? They're bullies at this point.
Well, I've made this point before, but another thing that's really important is if we look ahead to 20, you can't bring this case in next summer, right? In 2023 or something, because you're going to have an election. And if it goes the wrong way, there really will be no 601As.
Yeah,
and there really really will be no 601s. Like, you have to get in now and get your because let's go back to the process here. If you are successful and you get a 601A approved, you still got to get your interview. And a lot of the consulates and embassies where you may or may not be assigned to, it's going to be another 8 months, maybe longer. So
Juarez is a year at least. So
yeah, so we're trying to do it, fight the good fight, put everyone in a position, because the next hurdle is a battle in and of itself, getting an interview.
Well, this is, I mean, first and foremost, the most important thing is to get our plaintiffs' cases approved. But, a secondary thing that's going on here is you talking about the election. Let's say that the government wins not just this case, but on all these kind of cases, and the courts say, okay, no unreasonable delay cases on these discretionary applications. Well, what's to stop after the election, the next time somebody like Stephen Miller is in power, saying, okay, we're going to assign one adjudicator for these kinds of cases that I don't like, all over in every category, and we're going to reassign everybody else in the agency to whatever fraud, FDNS. Well, there's not going to be anything that courts can do about it. They'll basically grind immigration processing for categories they don't like to a halt. Those are the stakes here.
100%. I actually think if you go back, the Muslim ban, healthcare insurance bans, those are just consular decisions. Those proclamations, they come back with teeth because they actually learned how to write them now. and they can write them in a way where it's almost impossible to get judicial review. So yeah, I mean, you're talking stakes, and there may be 40% of the United States who would vote for that, unfortunately, and that's why voting matters. But also that this administration doesn't understand, in my view, in my opinion, they've missed a giant opportunity to actually help push immigration to the place where it needs to go. We talked about Canada versus the United States. We've missed some giant opportunities. There's nobody who understands it. I mean, I just don't think there's anyone there who cares.
Susan Rice.
I don't need to name names,
Did I mention Susan Rice is the reason we haven't fixed any of this stuff? I think I have.
I do think Orr is trying to change direction on the Titanic. It's just that it's really, really hard.
No, they're not. They have not made any effort at all, really. All right, what's next in the lawsuit? I don't know which lawsuit you're talking about. Did you hear an H1B number? We talked about that. Recently, if he's going waivers approved. Again, if you see it, you've got to email that to us so we can get on there. Yeah. Also, the judge decided discovery this week. Yeah, I would hope so. No, the judge not. I'm sorry. Discovery is pending in the 85 case. It's not currently pending on 601 case. The judge rules against the government motion to dismiss. We will then file for discovery.
We're working on a schedule with the anticipation that this case goes forward that allows for discovery in a full trial. So we're working on that.
All right. So as far as I know, they have, because people were mentioning they've been approved. Okay, DB 2021. I mean, yeah, it's pending. Joanna, Friday I got word from Attorney Jennifer Keating here that my case was transferred to the facility. That's it's going to Hart, because they're telling the court that Hart's already processing cases. They told the court that, so they had to actually do it. So, but apparently they didn't do it for everybody. Screenshot, you're great. Approved on July 2022. All right, you need to. But when did they file it? Did they file it in 2022? Get us what you got.
Yeah.
U.S. citizen filed for better more than 13 years ago, living in the U.S. Lord, didn't do this. Look, if he filed 13 years ago, they only have another 5 years to wait.
I think they're saying that NVC expired. So,
well, I don't know. Your question is unclear. Sorry.
Yeah, that's weird.
Is it true that end of fiscal year I'll go to transfer to? Where do you just make this shit up? I mean, really? Where are you getting this crap? Really? I'm sorry. Just making stuff up at this point.
Your point is whether they are on notice of all the plaintiffs and go, and that's been communicated around. Yes. That doesn't really mean that the cases have been sent.
They were ordered to actually keep working toward fixing their situation so that if there was an order that went against them, they wouldn't have to say, oh, we have to,
They told them not to destroy the files. Great. Thank you. Yeah. That's all that happened. Can I hire an individual suit to make this? An individual suit will likely, you can hire Jesse. I mean, we all do it, but I doubt they will make it go any faster given the pending litigation.
Yeah, I don't think so.
Hey, Dennis, work on the travel doctors going to guaranteed. That would be nice.
Sure.
All right, guys. Great to see you. Sorry for my language this week. You can tell I'm a little frustrated sometimes with this stuff.
It's because you got stung by a bee.
And I got stung by a bee. My face is mostly not swollen anymore, but I got peaked right there. They got it inside my bee suit. Yes, I have beehives in my free time with my farm. Planting corn this weekend, by the way. Have a bunch of sweet corn in about 75 days. Awesome.
Wow.
All right, so we'll see you guys next Tuesday. I'll be live tomorrow at 1. Much thoughts and prayers. Jesse, what day next week is your argument?
Thursday.
All right, so we'll give you thoughts and prayers next Tuesday in our broadcast.
Yeah.
All right. Take you guys later. Talk to you later. Bye-bye.
Later.